Good morning and welcome to our webinar, Virginia Common Interest Community Law and Regulation Updates, presented by Whiteford, Taylor, and Preston. Today's presentation is approved for 2 hours of continuing education requirements for common interest community managers, as well as by the Community Association Managers International Certification Board. Please note this session is being recorded. You will receive a link to the recording and a copy of the slide deck within 72 hours of the completion of this program. Please note the presentation material will run a full 2 hours, leaving time for questions at the completion of each presenter's section. Simply type your questions into the chat at any point during the presentation. And now, without further ado, I would like to pass the presentation over to Chad.
Again, welcome to this webinar hosted by Whiteford, Taylor, and Preston to share with you common interest community law and regulation updates. Your speakers today are Community Association attorneys from Whiteford, Taylor, and Preston. Together, we love all things Virginia. We love all things up and down I-95 from Northern Virginia to Fredericksburg to Richmond and turning east to Williamsburg and west to Charlottesville and I-64. And we love almost all things about common interest communities. While we hope that you will learn or be refreshed about common interest community law and regulations, we know that some of you are here for the credit too. This course is approved by the CICB as a 2-hour training program. This course is also approved by the CAMICB for 2 hours of credit toward the CMCA designation. With you, we want to navigate common interest community law and regulation updates in about 20-minute increments. Please type any questions that you have in the chat, and we'll answer those that we can within the 2-hour period and stay on afterward until all questions are answered. As you probably already know, we have a lot of ground to cover. So without further ado, here are my excellent colleagues, attorneys Claudia Lopez, Marla Diaz, Nasim Saidi, Katie Murphy, Michael Gartner, and Ed O'Connell. But first, please stay with me for the next 20 minutes. Next slide. I'd like to begin today with a paradox. It is true that we are about to spend our next 2 hours together discussing updates on a set of law and regulations called Common Interest Community Law and Regulations. Note the capital C, I, C, and L on the slide. That capital C, I, C, and L are capitalized because common interest community law is probably a lot less than you think. Common interest community law only includes number 1, your Virginia Property Owners Association Act for property owners associations. Number 2, your Virginia Condominium Act for condominiums. Number 3, the Virginia Real Estate Cooperative Act for co-ops, and number 4, the Virginia Real Estate Timeshare Act for timeshares. That's it. That's all common interest community law is, and the updates to common interest community law that have occurred recently is all we've been approved to discuss with you for the next 2 hours. Next slide. So if you think we may miss covering one or more of your favorite topics related to common interest communities today, know that you are right. And we definitely are going to miss covering some of those topics because common interest community law that we are approved to speak of today is far narrower than all of the federal, state, and municipality levels that can govern community interest communities. For example, common interest community law that we are approved to speak of today excludes the Federal Fair Housing Act because fair housing applies to not only common interest communities, but landlords and tenants too. Common interest community law that we are approved to speak of today excludes the Virginia Non-Stock Corporation Act because the Non-Stock Corporation Act applies not only to common interest communities, but non-stock corporations too. And common interest community law excludes interpretations of your association's declarations and bylaws because declaration and bylaws are not laws passed by your legislature at all, but rather declarations and bylaws are agreements made between your associations and their members, to which the terms of those agreements are covenants that attach to the members' lots or units. So after these next 2 hours, will you ever care about the distinction between whether any law is just common interest community law with all capitals or a law that governs more than just common interest communities? Probably not, unless you're considering a complaint that your association has violated common interest community law under your association's internal complaint procedure. But we'll discuss updates about internal complaint procedures a little later because internal complaint procedures are part of common interest community law. So what's an update of common interest community law? An update includes any amendment made over the last 5 years or so to the Virginia Code, and in particular, the Property Owners Association and Condominium Acts that are found in the Virginia Code. An update of common interest community law also includes any decision made by the Supreme Court of Virginia interpreting what the Property Owners Association and Condominium Acts may mean. Now, note that a change to the Property Owners Association and Condominium Acts and a decision from the Supreme Court of Virginia are binding. It means our associations have got to follow them. But there is another set of updates that we've been approved to discuss that may not be binding on our associations. Allow me a moment to provide some context. First, Virginia has 3 tiers of courts: a Supreme Court, Court of Appeals, and a whole bunch of circuit courts. Now, I say a whole bunch of circuit courts because there is one circuit court for almost every city and county in Virginia. Now, each court, the Supremes, the Appeals, and the circuits can write decisions about their cases. As mentioned, the Supreme Court's decisions are binding. The Court of Appeals decisions are binding too, although we don't have very many just yet, but believe me, they're coming. So enough with the context. I'll get to my point. Circuit court decisions are not binding. The decision of a circuit court in one county does not bind a circuit court in another county. The decision of a judge in one circuit does not bind any other judge where that judge presides, even if in the same circuit court. So should we disregard decisions by circuit courts? Of course not. Circuit court decisions are persuasive. They can provide guidance on an issue when there is no other guidance on that issue. Now, promise me that when you see a cite to a case in the slides today that has the word circuit court in it, remember, that case is not binding, meaning that the parties in that case must follow the decision. But must your association follow the non-binding decision? No. Should you ask your association's attorney whether it's a good idea to follow a non-binding decision? Yes, because that non-binding decision may very well be found and used by your opponent to try to persuade your judge when your association is part of a lawsuit. Whether to take that legal risk is always something that should be thought out well in advance of any litigation. Now, non-binding decisions do not end with the circuit court. There's another whole bunch of determinations written by the Virginia Common Interest Community Ombudsman. Much like circuit court decisions, ombudsman's decisions are not binding, but ombudsman's determinations can provide guidance on an issue when there's no other guidance on that issue. And at this moment, I believe it is a correct statement that there are more ombudsman's determinations on common interest community law than decisions from the Supremes, the Appeals, and the circuit courts combined. Now, again, promise me today that when you see a cite to a determination that has the acronym CICO in it, remember that determination is not binding, but still probably a really good idea to follow. Next slide. Finally, let's begin. Condominiums are not legally created when they are built but rather condominiums come into existence legally when their condominium instruments are recorded in the land records in the city or county in which the condominium is located or to be located. That we've known since 1977, which I say confidently as someone born in 1976. Next slide. But property owners associations are separate and distinct from condominiums. They are decidedly not the same thing. And it was as recent as 2017 that we are reminded that the property owners associations are entities subject to a declaration that must be recorded, must require its association to maintain common area, and must authorize that association to impose assessments to maintain its common area. Next slide. And let's face it, maintenance requires money. In that 2017 decision called Shepherd, the Supremes found that a declarant quixotically gave the responsibility for maintenance and the authority to impose assessments to perform maintenance to an association's architectural committee and not necessarily the association's governing board itself. Therefore, the Supremes found it was the architectural committee that was the property owners association, but not necessarily the board itself. Truly bizarre. Of another note, the Virginia legislature renumbered the entire Property Owners and Condominium Acts in 2019. This seemed like an incredibly big deal at the time, which now merits nothing more than a footnote. We've all adjusted to the new numbers. Next slide. Although property owners associations and condominiums are definitely different, as you know, they have many similarities. Their first similarity is they both begin under declarant control. The Property Owners Association and Condominium Acts address a few things that a declarant must do. For POAs, there are limitations on the terms that a declarant may agree to with an association's management company, as seen on the slide. For condominiums, there are disclosures that declarants must make to potential unit owners and bond requirements to ensure that declarants keep the promises that they make in those disclosures, also seen on the slide. Next slide. The responsibility for public offering statements, where some of those disclosures I just mentioned must be made, we know is solely the declarant's responsibility. The Ombudsman determined that there is not a responsibility under the Condominium Act for associations to update public offering statements after control of that association passes from the declarant to the unit owners. Now, remember your promise to me. See CICO on the slide? Is this Ombudsman's determination binding and the final word? No. Is this Ombudsman's determination a really good indication that unit owner controlled condominiums do not have to update their association's public offering statements? Absolutely. Next slide. There comes a time in every association's existence that control of that association passes from that association's declarant to that association's members, be it the lot owners in a property owners association or the unit owners in a condominium. When that transition happens, the Property Owners Association and Condominium Acts address a few more things that a declarant must do. For both POAs and condominiums, the declarant must provide a number of documents about how the business of that association has been conducted. For example, the association's contracts, financials, and some other documentation seen on the slide must be given to the members now on that association's board or to the association's management company. Next slide. For condominiums, the Condominium Act also requires the declarant to warrant against any structural defects in the common elements. We know that a structural defect can be any of the types of defects shown on the slide. For example, the defect must affect stability or safety of the building, or the defect must affect the normal use of a component of the building. Next slide. When a defect is discovered, that defect in, let me start over. When a defect is discovered, when that defect in fact began, and the notice sent to the declarant of the defect becomes significant. The declarant's warranty lasts for 2 years, and the warranty begins in most circumstances when the first unit in the condominium is sold to a unit owner. We know that the warranty applies to only those defects that arose in that 2-year period. Now, defects may be discovered after that 2-year period, but they will only be under warranty if they began during that 2-year period. Then, notice must be sent to the declarant of the defect once the defect is discovered. And while a decision from the Supremes from 2009 on this point does not qualify as an update, nonetheless, it's worth mentioning here that then the Supremes held notice to the declarant must state statutory language about structural defects. For example, this defect affects the stability or safety of our building, or this defect affects the normal use of a component of our building, which leaves me very tempted to say that when it comes to sending a notice of a structural defect to a declarant, do not attempt this at home. Use trained professionals such as your engineer or an attorney. Next slide. And just like that, the declarant is gone. The association's members are now responsible for conducting the business of the association. Great. Now what? For POAs, follow the declaration that documents which either and probably both makes the association responsible for its common area and authorizes the association to collect assessments to maintain that common area. For condominiums, follow their condominium instruments, of which the most significant are the condominium's declaration and bylaws. Now do that and everything's fine, right? You and I both know the answer to that. Next slide. Declarations and condominium instruments are often old. They have not aged well, and for a multitude of reasons, a multitude of owners in an association do not like their declaration or condominium instruments, and they wish to change them. Candidly, that's okay. To amend either a POA's declaration or a condominium's condominium instruments, by default, 2/3 of the members of either that POA or condominium must approve the amendment. The declaration or condominium instrument may itself set a number besides 2/3 to amend, such as a majority, and that's okay. If the declaration or condominium instrument sets a number besides 2/3 to amend, we use that other number. Next slide. In 2016, I believe it's safe to say that any amendment of a declaration or a condominium instrument was done with paper ballots or paper ratifications of that amendment. We already knew in 2016 that amendments of a declaration or a condominium instrument were not effective until they were recorded among the city or county's land records where that POA or condominium is located. We also knew that the ballots or ratifications themselves did not have to be recorded, but the president of the association could certify that the necessary ballots or ratifications had been collected, and the president's certification could be recorded instead of the members' ballots or ratifications. The Supremes held in 2016 that those members' ballots or ratifications had still better be signed by the association's members. Fast forward to today, please ensure your ballots or ratifications of amendments to your association's declaration or condominium instruments are signed by your association's members who approve those amendments if your association is still using paper ballots. Next slide. Finally, we arrive at our first update that I think really has significantly changed the way associations can conduct their business. Goodbye and good riddance to paper ballots, almost. As long as an association's declaration or condominium instruments do not prohibit electronic voting, and thankfully, most declarations and condominiums are old, so they don't, associations members can vote electronically. The mechanics of electronic voting are discussed later today with topics that are more pertinent than my general introduction to electronic voting at this moment. For those mechanics of electronic voting that do not fit neatly elsewhere, Let me say now that electronic voting is great, but associations have to keep electronic voting records the same as they keep paper ballots and other paper voting records. And associations must provide alternatives to members who do not want to cast a ballot electronically. For example, a paper ballot or proxy not only should, but must be given to a member who does not want to vote electronically if there is no other alternative. Now, be alert, the Uniform Electronic Transactions Act also affects those associations engaging in electronic balloting. I will not talk about the Uniform Electronics Transaction Act today because it is not yet part of common interest community law with capital C, I, C, and L, as I mentioned about 20 minutes ago. But of course, pull me aside during a break if you wish to discuss the Uniform Electronic Transactions Act further, because of course, who wouldn't? Next slide. Again, electronic voting is great. And I believe it has increased member participation in associations. But electronic voting still does not guarantee the necessary number of votes for an amendment will be cast, or quorum will be reached for a meeting of the members. If an association does not get the votes, it does not matter how much an amendment or an election is needed, the amendment does not pass or the election cannot be held. But the association may not yet be without further relief. On any issue that a declaration or condominium instrument is silent, the Property Owners Association or Condominium Act may supplement that declaration or condominium instrument. For example, the Property Owners Association Act may provide authority for a special assessment or a late fee where a declaration does not say anything about a special assessment or a late fee. Both the Property Owners Association and Condominium Acts may provide authority for a board to adopt rules about certain conduct by members where a declaration or condominium instrument is silent about that conduct. Now, my last couple of slides deal with scenarios where a declaration or condominium instrument conflicts with the Property Owners Association or Condominium Act. But if your association is in that scenario where you believe there is a conflict, please engage the association's legal counsel rather than use my last couple of slides to resolve that conflict. I pause now for any questions you may wish to ask. Otherwise, I turn it over to my most excellent colleague, Claudia Lopez. Thank you.
No questions at this time.
Perfect. Thank you, Chad. If I can have the next slide, please. I think one more. There we go. So we're going to begin with meeting requirements for members, starting first with property owners associations. So a meeting for members, must be held at least once a year. Notice must be provided at least 14 days in advance for an annual meeting or regularly scheduled meetings. Any other type of meeting, however, only requires 7 days advance notice. The notice must state the time, the place, and the purpose of the meeting. The notice can be sent through the US mail, it can be hand delivered, or it can be sent by email. Next slide, please. Looking at condominiums, the requirements are nearly identical. So again, there must be a meeting held at least once a year, except the notice requirement differs here in that for an annual meeting or regularly scheduled meetings, the notice must be sent at least 21 days in advance. Any other meetings require 7 days advance notice. And again, the notice must state the time, the place, and the purpose of the meeting. And it can be sent by US mail, it can be hand delivered, or again, it can be sent by email. Slide, please. So, as I'm sure everyone can recall, 3 years ago, COVID essentially stopped everyone in their tracks. We all had to figure out, how do we keep doing what we need to do without leaving our homes essentially, right? We all had to quarantine. We had to figure out how remote work was going to function. And this applied to associations as well. They had to figure out how to handle their business electronically. And so the question became, okay, if we can't meet in person, do we still have to hold an annual meeting for the members? And the answer was yes. And so this very question was brought before the Common Interest Community Board, and the Ombudsman decided that although COVID did make it more difficult, perhaps, to coordinate a meeting, it was not impossible. The reason being that there is the ability to hold meetings electronically. And so the answer was yes, all associations still have to hold at least one meeting per year. So in terms of notice, the nice thing is that had already been in place. You are allowed to send notice electronically as long as the declaration or condominium instruments don't expressly prohibit it. And as Chad mentioned, for the most part, these documents are pretty old and don't address it. And so that works to the association's favor. Next slide, please. Okay, so if we can send the notice by email, that resolves that issue. But what about the meetings themselves? Well, all member meetings, meetings of the board, committee meetings, they can all be held using an electronic platform, such as the one that we're using right now. However, there is a requirement that the board must adopt guidelines in order to use such platforms. And the guidelines have to ensure that the persons accessing the meetings are authorized to do so. In addition, the association has to make a reasonable alternative available for those who are unable to join virtually. And so the nice thing about a lot of these platforms is it allows you to have control over who joins. So as we're presenting right now, we can see, okay, this person has joined, and then we have the ability to say, okay, yes, they're supposed to be participating in this meeting. We can go ahead and admit them. And so as long as there are guidelines in place, then an association can hold whatever meeting they need to electronically. And so that resolved that issue. Next slide, please. And so we can send notices electronically, we can hold meetings electronically, but what about voting? So again, unless expressly prohibited by the governing documents or the condominium instruments, a member can vote at an association's meeting in person, by proxy, by absentee ballot, and voting can take place by electronic means. Again, however, the requirement is that the board must adopt guidelines for electronic voting. Importantly, members voting by absentee ballot proxy will be deemed present at the meeting for all purposes. So again, when COVID first hit and everyone was trying to figure out what they needed to do, we were drafting a lot of resolutions that addressed these specific requirements within the statute, making sure that there were guidelines in place for electronic voting and electronic meetings. And Chad touched on the electronic voting earlier. Next slide, please. So turning to board of director meetings specifically, there are certain requirements in place as well. So again, it always comes down to what the instruments say, but unless a declaration or condominium instrument specifies a larger majority, a quorum is deemed present throughout any meeting of the board if persons entitled to cast 1/2 of the votes are present at the meeting. Now, here's a really important bullet point that I want to emphasize. All meetings, including committee meetings, are open to members. So informal gatherings cannot be used to circumvent this requirement. Group chats, group text messages between the board members cannot be used to circumvent this requirement. Work sessions, all of that cannot be used to circumvent this requirement. This requirement is in place is especially to allow all the members to see what is it that my board is discussing? What is it that these board members that are in charge of making decisions for our community, how are they coming to these decisions? What are they discussing in these meetings? It's all about transparency. And so, again, all meetings have to be open to the members. And because of that, again, the notice becomes really important. So it must state the time, the date, the place of each meeting so that members know when and where the board is going to meet. And if they choose to, they can sit in on the meeting as well. Now, sometimes there are emergencies, there's a need for a special meeting. In that case, then you still want to try to send out that notice if you can at the same time that it's provided to the board. Next slide, please. So again, the goal is transparency. So any member may record any portion of a meeting that is required to be open. However, the board can adopt rules regarding the use of recording equipment, and that really applies more if you're in person. For example, if somebody whips out their camera, or in the good old days, whipped out a tripod with one of those really big cameras I remember my dad used to use, that type of thing. But also if we're using this type of platform that also allows for recording, the board can adopt those rules and those regulations, as well as requiring notice be provided that the meeting is being recorded, so that people who maybe don't feel comfortable being recorded are at least put on notice of that. The board must also allow owners the opportunity to comment on any matter relating to the association. So you have an open meeting, members are present, they're going to observe what's going on. They might have some comments that they want to share with the board, then they're going to be allowed to do that. However, the board may limit comments to the topics listed on the meeting agenda for special meetings, or a meeting in which the agenda is limited to specific topics. Next slide, please. Executive session is also a part of the meetings. And now this portion of the meeting is not going to be open to the members. So if the board needs to, they can convene an executive session. But again, they can't use this to simply circumvent the open meeting requirement. So if the board is going to convene an executive session, they can only do so to consider personnel matters, consult with legal counsel, discuss and consider contracts pending or probable litigation, discuss and consider violations, and discuss and consider the personal liability of members to the association. So other than that, if that's not what you're discussing in executive session, then you need to be having the discussion in the open part of the meeting. And even then, if the board comes to some conclusion, makes some kind of determination during executive session, no contract, motion, other action that's adopted, agreed to in executive session will become effective unless the board of directors reconvenes an open meeting and takes a vote. And so that's an important step that the board has to remember to take. Next slide, please. So what's new? So as we've mentioned, any type of meeting can be held using an electronic platform. Interestingly, the requirement used to be that that two members of the board were required to be physically present at the meeting place that was included in the notice. However, that's no longer the case. So the law was amended to allow for wholly virtual meetings. And so that definitely helps to make things a little bit more convenient. And again, the concern with COVID was, well, if everyone's supposed to be essentially sheltering in place, you're not supposed to leave your home, you're supposed to quarantine, then that became a conflict. But that's not a requirement anymore. Additionally, the requirement that the board provide a reasonable alternative, it has not been determined to mean that if everyone's attending a virtual meeting, that that's necessarily going to equate to conducting business. And therefore, the association has to provide an alternative for an owner who doesn't want to attend a meeting virtually. And so in the Fowler case that you see here, there was an owner who did not want to attend a meeting virtually, complained that the association had to require an alternative so that this owner could participate essentially in person. And when the ombudsman looked at the case, basically determined, well, the statute says if you're conducting business, then you have to provide a reasonable alternative. But attending a meeting doesn't necessarily mean the association is conducting business. And so ultimately, the association is not necessarily required to also provide a physical location if they're holding their meetings virtually. Next step, please. So rules and regulations. We're all familiar with different types of rule regulations that associations can pass, sometimes that they want to adopt, necessarily can't. So we've highlighted some that are specifically addressed in statutes. So starting with property owners associations, the first one we're highlighting is the rental of lots. So associations can require the names, the contact information, and the vehicle information for tenants, as well as the name and contact information for any authorized agent of the owner. Sometimes the owners handle the leases and the renting of their lots themselves. Sometimes they have a property manager. So whoever it is that the association needs to contact, they need to have that information. And then they can also require that the lot owner provide the tenant's acknowledgement of and consent to any rules and regulations of the association. And again, this is just to ensure if you're living in our community, we want to make sure that you're aware of the rules, what you can and cannot do. Next slide, please. And the ability for the association to adopt rules and enforce them is set forth in a statute. And so it specifically says the board has the power to establish, adopt, and enforce rules and regulations with respect to the use of the common areas and areas of responsibility assigned to the association by the declaration. Next step, please, or slide, please. So the flag, we've gotten lots of questions about this, and this is addressed in the statute. What it boils down to is the association cannot prohibit an owner from displaying the American flag. That being said, the association can establish reasonable restrictions as to the size, the place, the duration, and the manner of placement or display of the flag, if such restrictions are necessary to protect a substantial interest of the association. Next slide, please. Home-based businesses. So they are permitted. Again, it comes down to the document. So unless the declaration prohibits or provides otherwise, the association cannot prohibit an owner from operating a home-based business. But they can establish reasonable restrictions as to the time, the place, and the manner of the operation of the home business. They can also establish reasonable restrictions as to the size, place, duration, and manner of the placement or display of any signs related to this home-based business. And importantly, the business has to comply with all applicable local ordinances. Next slide, please. This is also a pretty big one, and as you can see, we've highlighted that this is new. So limitation on smoking in development. So unless the declaration provides otherwise, the board may establish reasonable rules that restrict smoking in the development, which includes the common areas. Next slide, please. This is also another new one, and it's it's come up quite a bit for us recently. The installation of solar energy collection devices. So again, looking at the declaration, if the declaration prohibits it, then the analysis ends there. But if it does not, the association cannot prohibit an owner from installing a solar energy collection device on the owner's property. They can establish reasonable restrictions concerning the size, the place, and the manner of placement of such devices. However, this is the really important part. A restriction is not reasonable if it increases the cost of installation by 5% or reduces the energy production of the device by 10%. Next slide, please. Another big one is the installation of electronic vehicle charging stations. So as long as there's no restriction in the governing documents themselves, the association cannot prohibit any owner from installing an electronic vehicle charging station. They can establish reasonable restrictions concerning the size, the number, the placement, manner of placement of these stations, but can't otherwise prohibit it outright. The association may require the owner obtain insurance covering claims related to the station. Okay, next slide, please. So this is a really important case, and this case, what it essentially says is that the rules and regulations must be within the scope of the HOA's authority under its enumerated restrictive covenants. So what does that mean? It means that if it's not expressly allowed in your documents, then you can't get around it and just grant the association the authority to do something through rules and regulations. So step one, what do the documents say? Do they allow the association to do what it is they're trying to do? If it does, great. You can cite to the language in the rules and in the resolution setting forth these rules and regulations. If the language is not there, though, then in adopting a resolution that sets forth rules and regulations that do not have the authority within the documents can end up getting the association into a lot of trouble if a lawsuit ensues. And this is the case that we usually cite to for that, and that stands for that proposition. Next slide, please. So we've done the same thing for condominiums. We've summarized the important statutes, and I won't go through each one of them because they're nearly identical to the ones for the Property Owners Act, but I'll just briefly highlight them. So the requirements are the same as they are for the property owners associations for the American flag. Can't prohibit it, but you may have some reasonable restrictions on it. Next slide, please. And again, for condominiums, there is a statute that specifically sets forth that the board can establish, adopt, and enforce rules and regulations in respect to the use of the common elements and areas of responsibility that are assigned to the association by the condominium instruments. And I will highlight 55.1-1960 on the bottom of the slide, which says that if it's expressly provided in the condominium instruments, then the association can limit the number of persons who may occupy a unit. Next slide, please. And similarly here, for rental of units, the association can require the same information that a property owners association can require owners to provide. So contact information, vehicle information, that type of thing. Next slide, please. And there's also a statute that governs the installation of solar energy collection devices. And the wording is exactly the same. And I'll focus again that a restriction is not reasonable if it increases the cost of installation by 5% or reduces the energy production of the device by 10%. We get a lot of questions regarding this, and we always go back to the statute. Next slide, please. Similarly, we now have a statute that allows for the limitation of smoking in a condominium. So the board can establish reasonable rules that restrict smoking in the condominium, including the common elements and units. And then focusing on the last statute here, electronic vehicle charging stations are permitted. The association cannot prohibit an owner from installing one unless the condominium instruments provide otherwise. However, the association may prohibit the installation if it's not technically feasible or practical due to safety risks. Next slide, please. And as you can see, the statute pertaining to electronic vehicle stations or vehicle charging stations for condominiums has a long list of what the association may require from the owner. So this is a little bit different from the statute that we highlighted for lots. And it makes sense just because of the dynamic of a unit versus a lot. And so there are a few items, as you can see here, we've identified for you that the association may require. And that is my last slide. I think I saw some questions come in.
Yes, Claudia, there's one question that came in from Laura regarding meetings. So has the statement where a reasonable person can assume that the majority of the members have been notified been removed?
I'm going to pull up the, looking at the, it has the statement where a reasonable person can assume that the majority of the members have been notified, been removed. So I am going to just ask for a little bit of clarification there. The statement being from the statute, is that the question?
Wait for Laura. I can take her off mute to ask as well. Or here comes Chad.
I'm cheating. I'm texting Laura right now. No, that those provisions remain in the POA and Condominium Act. It's not Claudia who omitted them. It was I who was her editor. I could not fit them on the slides, but they may remain alive and well.
And that's a really good point, Chad. We highlighted what we could in the presentation and the slides just because of there's only so much text that fits in the slides, and we're each limited to the portions that we're covering. So good questions. But yes, please, we've cited to the statutes at the bottom of each slide. And so please reference the statutes if there's anything you feel we left out. Okay, were there any other questions, Rachel?
No further questions at this time, Claudia.
Okay. Well, thank you. That concludes my portion of the presentation, and I will hand it off to Chad. Who is it that comes after me?
Marla and Nassim.
Marla and Nassim. Thanks, guys.
Thank you, Claudia. Good morning, everyone. Nassim Saidi here, and I'm Associate Attorney at the Community Association section of Whiteford Taylor Preston. And Marla and I are here to discuss the association's duty to maintain condominiums. We're also going to talk about property owners associations and what are some common interest laws on how to fund those responsibilities. If I if you can go to the next slide, please. Thank you. So the number one thing to take a look at is what is the responsibility of the condominiums with regards to maintaining the common maintaining the association. And the number one thing is that the requirements that the condominium associations have a duty to maintain, replace, repair, and restore capital components. So what are capital components? What does that mean? So that may include parts of the common elements, limited common elements, and units depending on the requirements of the condominium document. So it's really important to take a close look at the condominium documents to determine what those capital components are and what the association is specifically responsible for. So generally, absent to the contrary requirements of condominium documents, association is financially responsible for maintenance, repair, and replacement of the common elements, and that includes limited common elements. In case of casualty, for example, if there's a fire or a flood, however, in that case, association is also likely responsible for the unit repairs. Next slide, please. Similarly, in the Property Owners Association Act, it does not impose duties to maintain capital components and generally leaves it to the board's discretion to determine the appropriate funding of the maintenance issues for the common areas. Again, generally you have to make sure that the association is in compliance with the declaration. The POA Act does require that compliance, and it includes the association's duty to maintain common area, which generally specifically exists in the declaration. Capital components include but are not limited to common areas or property owned, leased, or maintained or operated by the association. Next slide, please.
So now Nasim has told you about what your association's responsibilities are going to be with regard to maintenance and upkeep of your capital components. The next question, of course, is how are you going to pay for that? So there really are three main ways that your association is going to have the funding necessary to do the maintenance and repair. And a lot of it's really going to depend on what kind of work it is you're talking about. Typically, if what you're discussing is a repair or a replacement, when the portions of the property, parts of the capital components have reached the end of their useful life and you need to repair and replace them, that's typically something that's going to be funded from your reserve account. So those amounts that your association has been reserving against over all of the years, that's typically where you're going to get the funding for repair and replacement. When instead what you're talking about is your maintenance, so the upkeep that you have to do to oil the joints and those sorts of things throughout the year, that's typically part of your maintenance budget that you're going to include annually to do those kind of maintenance tasks that the association's obligated to do just to upkeep the property generally and prevent you from needing to do repairs and replacements. And then the last area of funding is the area of insurance. And this is typically when you have some sort of casualty event, a fire or a water leak, that causes damage to your association. Often your funding is going to come from your insurance in order to address those particular casualty issues. Next slide, please.
So we discussed earlier about ombudsman cases that they are not binding. However, they provide some good guidance with regards to the common interest laws. One of the cases we mentioned here, the Spencer Taylor case, in that case, there was a complaint made to the CICO because the association had used the association funds to update and repair all the unit private toilets. And in that case, there was actually a decision that came out from the ombudsman that said that that particular maintenance was not authorized by the condominium documents. It was considered improper use of the association's funds. So the general takeaway from that was to make sure that if the association is using its funds for a particular thing, that there is a specific authority in the condominium documents for it. The second case we mentioned is a Nichols case, and that one, there was a complaint made stating that the association's reserve did not was not complete, that it was not it did not provide the full funding for the association. That particular case, the ombudsman actually decided that it had no jurisdiction over this particular issue, because that is really within the discretion of the board to decide what's for the best interest of the association when they fund the reserves. They're not particularly required to fully fund it. That's just up to the board. They can fund it over the year. That just shows that the authority to act and the manner in which to act it, in the manner to which to do it, actually comes from the board itself. And, next slide, please.
So we talked a little bit about reserves, and as I'm certain most of you already are aware, there is an obligation under both the Property Owners Association Act as well as the Condominium Act that the association in every 5 years conduct a reserve study in order to determine what is necessary and the amounts of reserves that the association should be saving in order to be able to make the repairs and replacements and restorations of capital components as those items reach the end of their useful life. And obviously we typically do this, or you really should be doing this, with a reserve engineer who has the expertise to provide you with this information. And this really is intended to be a budgeting tool. It's not a guarantee to say that if the reserve engineer suggests that your roof's going to need to be replaced in 20 years, that means in 20 years on the dot, you need to be replacing your roof. It means that's an expectation and you should budget against that possibility, but it's not a guarantee that you're actually going to need to replace the reserve then, or replace the roof then. Nevertheless, what you should be doing is recommending to your boards of directors that annually they're taking a look at that reserve study and seeing whether or not there needs to be any adjustments made to that. If you are discovering that your roof is in fact in worse shape than it was anticipated the last time that your reserve engineer looked at it, then it might be necessary to adjust your reserve contributions because you might need to replace the roof earlier than you anticipated, or vice versa. It might be that the roof's going to last longer, in which case you can adjust your reserve contributions similarly, but you are going to want to consult with your reserve engineer when making those decisions, but definitely take a look at it annually. You should also, when you're considering your budget for reserves on an annual basis, and when your board is contemplating what they're going to contribute to their reserve account annually, you should be taking a look at what the current estimates are for the replacement cost of those capital components included in the reserve study, what the anticipated remaining life is, and whether you know any different information about the useful life, whether you do know that that roof is going to last longer or that it's going to have a shorter life because you had some other contractor come in the interim and given you a different opinion about that. And that can help your board make an appropriate determination as to what their annual reserve contributions are going to be. Next slide, please. In terms of what's new, there are a couple of fairly new items that have been added to both the Condominium Act and the Property Owners Association Act when it comes to what your obligations are with regard to your reserves and your annual budgeting for reserves. And really the intention here is to provide a little bit more notification and advisement to the owners in the community, because obviously most owners are not savvy enough to actually take a look at your reserve study or to really understand what it means to make an annual reserve contribution until they get on the board. That's just not something they consider the details of. So what you are now required to do is in your annual budget for when you do your annual budget, you are required to include a statement that says what the recommended amount of reserves are from your reserve engineer. What are they saying you should be saving every year? And if you're saving different, then if your budget contemplates a different reserve contribution annually, then you need to be providing an explanation of that to your owners. You also are required to give them a statement of what your replacement reserve balance is at the beginning of the year, what you're anticipating it will be, and then what you're going to be contributing to it over the year. So again, if they want to, they can take a look at your reserve study and see whether or not your replacement reserve balance is where the engineer expected it to be, so that they know whether you are under or over reserving, and they can then provide you comment on that. Obviously, also because these budgets are going to be available to potential owners, it helps them make decisions as to whether or not you are a financially sound community that is appropriately reserving, or whether or not they're going to be looking at a major special assessment in a couple of years because you haven't been saving enough for the upcoming roof replacement. You do have to make this information either available as part of your annual budget, or you need to provide a summary of your annual budget prior to each fiscal year, unless your declaration or condominium instruments say otherwise. So again, your owners have this information in hand before the fiscal year begins, and they can provide you comment if they disagree with how it is that you're handling those reserve accounts. Next slide, please.
And with that, there have been many complaints related to how the reserves are funded that are made to the CICO. One of them is the Wiseman case, where there was a complaint made with regards to how the reserves were funded. And in that case, again, it was established that the budget can be developed over time as needed, depending on the needs of the community, and that it doesn't have to be fully funded. It's up to the board to determine how much they want to contribute to the reserves, because as always, they want to make sure that they save enough that if something were to happen, that they have sufficient funds in the reserves, but the reserve doesn't have to be fully funded. There is also the Boziger case, where that one is a little bit different in a way that the ombudsman decided to make a decision on that instead of saying that it didn't have any jurisdiction. And that case was different because a reserve study wasn't done in the past 5 years, and it was very incomplete. It did not address all the capital components, and in that case, the ombudsman had made a decision to allow the association 90 days to update the reserve study and provide one, and that's generally because they hadn't done one in the past 5 years. And the third case, the King case, was also about how the reserves was funded. And again, in that case, similarly to Wiseman, it was decided that the ombudsman didn't have any jurisdiction. Again, it's for the board to decide what's for the best interest of the association, what's appropriate with regards to the needs of the association when the board thinks about how they want to fund the reserves. Next slide, please.
So one of the things, though, that I think those cases that Nasim just talked you through, what I think is interesting about those, and I think is helpful to the association, is there is quite a bit of discretion that is given to the boards of directors to make determinations about what they are saving against the reserve. So like I said previously, you do have an obligation to tell your owners if you are making reserve contributions that are different than what the recommendations of your reserve engineers are. But the board is entitled to make those decisions, and they're entitled to say to their community, we don't think we are going to save as much, and here's why, or we're going to save more, and here's why. And they're entitled to make those. But the thing that I thought was particularly interesting about the one case was the ombudsman's concern where the association had in essence not included all of the capital components in their reserve study, and that was problematic. Not that the association had made a decision to contribute differently than what their reserve engineer had recommended, but that they hadn't made certain that their reserve engineer had included all capital components in that reserve study. So in essence, the reserve engineer's proposal, because they didn't have all the information they needed, was artificially low. And that's where the ombudsman's concern came in. So it is important to remember that one of your responsibilities as a board is to review that reserve study to make sure that all your capital components are included. But there's also going to be certain circumstances when it comes to charges that the association wants to make that are outside of what is specifically identified in your governing documents as what you can include as your common expenses. What you can actually charge against your owners for certain services and expenses of the association. So under the Property Owners Association Act, the association does have the right, if it's not expressed in even if it is not expressed in the declaration, to impose certain costs and charges against their owners, but those have to be related to services or they have to be for the use of the common area. For condominium associations, similarly, even if you don't have express authority in your condominium instruments for certain charges and expenses, you can charge or assess against your owners for specific services that the association is providing to them. So, for example, in unit services or things like that. There is, however, there just was a case that came out of the Court of Appeals, and I'm not going to belabor this too much because I think some of my colleagues might be addressing it too, but there was a recent case out of the Court of Appeals where the association was including as part of their common expenses the cost for a company to assist them with their ARB enforcement on the lots. And the Court of Appeals took a very strict reading of these statutes as well as the governing documents for the association and made a determination that it did not fall within the authority of that Property Owners Association Act to assess as a common expense the cost for ARB inspections on the lots outside of the resale disclosure inspections, but that the general annual inspections that they were paying an outside company to do for them was not something that they were expressly authorized to do under their declaration. And therefore, because it wasn't related to the use of the common area, which is what the POAA Act allows, they weren't entitled to include that as part of the assessments against their owners, which is a pretty tough reading of that statute, but one that I think we're going to need to be aware of when we start looking at how your property owners association or condominium association is spending money and whether it falls strictly within what your documents provide or the common expenses you're allowed to incur and assess against your owners. Next slide, please.
So regarding the association's authorities to charge fees, there are two cases. The first one is the Pilkerton case that specifically talks about a case where the association was charging for the hourly fee expense that they incurred for disclosure packets. In that case, the decision was that was not allowed because there was no, it was not specific as to who prepared the disclosure packets. It could have well been the board members. And because of the general rule in the documents that say board members are volunteers, they're not there to be compensated. So because of that, the specific charge to prepare the disclosure packets, especially by board members, is not allowed. In that case, it was decided that there was no actual cost for preparation that was incurred. The Edwards case, that was different. That case involved the charge. It was a $50 charge for ARC application fee for its preparation, and it stated that it's not in violation of the common interest community law. However, the ombudsman made it specific that it did not really have jurisdiction with this regard, that was something that was allowed under the documents. It was not violation of the governing documents. It was reasonable as per the documents say. So that decision again came, give the board discretion to be able to charge a reasonable expense for the preparation of the ARC application, as long as the authority to do so was in the governing documents. Marla, do you have anything else to add?
Not much, except to say that this new case we've got out of the Court of Appeals does somewhat inform these issues, and it's all of which is to say, I think associations are going to need to take a careful look at what when they are trying, particularly to assess things that are not expressly provided for in their documents. They're going to want to take a careful look at that Court of Appeals case and make certain that they're not exceeding their actual authority, because a savvy owner may start challenging assessments if they realize that what you're doing actually exceeds your ability to charge your owners under your governing documents.
All right, that was our last slide. Any questions for us?
No questions at this moment. We'll hold the couple that we have for the end of the program.
Thank you. That concludes our presentation. We are going to pass it to Katie Murphy. Thank you.
Okay, thank you, Naseem and Marla. Hello, my name is Katie Murphy, and today I'm going to be talking about covenant enforcement. Enforcement is a crucial function of associations because associations have rules in their recorded documents, as well as resolutions, handbooks, and architectural control guidelines. When those rules are broken or violated, associations must take enforcement action. How rules are enforced can become a bit tricky, as there are multiple limitations on when and how enforcement can take place. For one, associations must only take enforcement actions that are expressly authorized by the recorded documents. And two, even if the recorded documents authorize certain methods of enforcement, Virginia law requires associations to take certain due process procedures. Next slide. I'm sorry, next slide. Thank you. So what are the typical enforcement remedies? Common remedies are the suspension of privileges in the event an assessment is unpaid for a certain period of time, meaning suspension of the right to use certain amenities like the pool or the gym, and sometimes even the right to park on the common elements or common area. There's also, again, depending on the documents, the option to impose violation charges when rules in the documents are violated. Another common mechanism is suspension of voting rights or suspension of the right to serve on the board. Some documents will further authorize the suspension of privileges for violation of the rules, not just for delinquencies. Next, there's typically litigation authority, the right to file a lawsuit for unpaid assessments, or the right to file an injunctive relief claim to compel an owner to do something or stop doing something to compel compliance. Finally, most documents will provide a right of entry to the board or its agents in order to cure a violation. However, please note that no agent should ever disturb the peace or force entry into someone's unit or lot. If the agent is told no, the association should obtain a court order authorizing entry. Next slide. So again, the ability to take the actions on the previous slide depend on what the recorded documents expressly so provide. If the documents expressly allow a certain remedy, the Virginia Condominium Act and the Virginia Property Owners Association Act require due process procedures and also place a cap on things like violation charges. From there, associations should be aware of Virginia Supreme Court decisions, which may have further limited enforcement remedies. Next slide. So now we are going to drill down on violation charges. Again, if expressly provided, which at this point means you can literally point to a provision in the declaration or bylaws which says violation charges may be imposed, the association must then comply with requirements in 55.1.18.19 B through D or 55.1 B through D of the Virginia Condo Act or the Virginia Property Owners Association Act. The provisions in each are almost identical. They require notices and a hearing. They both limit violation charges to $10 a day for up to 90 days for violations of a continuing nature, like having a missing shutter, or $50 for a one-time violation, like leaving a trash bin out for an extra day in violation of the rules. Next slide. Okay, so the notices I mentioned are first, a notice of violation and opportunity to cure. If uncured after a reasonable period of time, which will vary depending on the nature of the violation, you move to the next notice, which is the notice of hearing. The notice of hearing by statute must include the actions or penalties which may be taken against the owner, and it must be sent at least 14 days prior to the hearing. It must be mailed by registered or certified mail, return receipt requested, or be hand delivered to the address of record required for notices. Finally, it must state the date and time of the hearing. Then there's the actual hearing. The violating owner will be given an opportunity to be heard, and sometimes an owner will explain that they're going through hard times or can't pay, or maybe a perceived violation was not actually the violation the board thought. The hearing is the time the owner has to basically make a case or explain an issue. At the hearing, the owner also has a right to be represented by a lawyer. After the hearing, the board must make a decision about 1, whether a violation occurred, and about 2, about what the penalty is going to be. Within 7 days of the hearing, the association must mail a third notice, the notice of hearing results, and again, it must be mailed by registered or certified mail to the owner at the address required for meetings. Next slide. So what's new with enforcement? Well, in Shadowwood versus Fairfax County Redevelopment and Housing Authority, the Virginia Supreme Court ruled that authority in the statutes to assess violation charges is not enough. The association's recorded documents must clearly state the association can assess violation charges. So if your association does not have the authority, what can be done? Not too much. It must go through the arduous process of amending its documents. It cannot simply adopt a resolution to have the right to impose violation charges. Next slide. Okay, so just like violation charges prior to suspending privileges for non-payment of assessments, the association must send the 3 due process notices discussed previously, as well as the hearing. One thing to remember prior to suspending privileges is that the association may not endanger the health, safety, or property of the owner or occupants. So do not cut off the heat when it's freezing outside. The association also may not prevent access to the unit through the common elements. It can suspend parking, pool usage, and some utilities like Wi-Fi. Next slide. Again, some associations provide authority for the association to suspend privileges for regular violations, not just for non-payment. The statutes do not address this scenario, so the statute does not actually require due process for suspending privileges for violations other than for delinquency, but it's probably best practice if the association has the resources to go through the due process requirements just in case. And also, obviously, if you suspend the privileges using this authority, the same things apply about not endangering the health or safety and not preventing access to the unit. Next slide. Okay, so now we shift to injunctive relief. Again, injunctive relief is a type of relief sought in a lawsuit when the association needs a court order to force someone to do or stop doing something. The pertinent statutory provisions are on this slide for your reference, but I'm not going to go through all the numbers. Next slide, please. So in order to prevail on injunctive relief, the association should establish whether irreparable harm will be suffered if denied, whether the harm to the association outweighs the harm to the defendants, and whether the injunction is in the best interest of the public. Next slide. In Ferron versus Old Bellhaven, the court provided that if a statute empowers the court to grant injunctive relief, the injunction need not contain an allegation of irreparable harm. So that's a good case to have for associations. Next slide. Okay, this is a good slide for me. Attorney's fees. If the association is forced to file a lawsuit, whether for debt or injunctive relief, the association is entitled to its reasonable attorney's fees if it is the prevailing party. And this is by statute. However, most documents will also have an attorney's fees provision as well. Next slide. In Lambert versus Sea Oaks Condominium Association, the court ruled that it is mandatory to award the prevailing party attorney's fees. So this is a good thing, so that a judge can't just deny attorney's fees. The court has ruled that the association is entitled to those fees if it's the prevailing party. Okay, and that wraps up my portion. I will now pass the baton to Mike Gardner.
Thanks, Katie. Hope everybody is surviving this invigorating discussion on a Friday morning. Next slide, please. I'm going to talk about some of the transparency and owner rights. One of the things to keep in mind is that common interest communities are membership associations. The unit owners are members of the association, and so they have fairly extensive rights to interact with the association and to observe and inspect the association's operations. One of the bigger rights in that regard is to inspect the books and records that are kept by an association. The books and records by statute can be examined by a unit owner who's in good standing. The owner has to provide the purpose for the request, and the purpose has to be related to his or her membership in the association. The inspection and copying needs to be done during reasonable business hours or at a mutually convenient time and location that the parties agree. There has to be written notice, and the association has 5 business days to respond to the notice, assuming it's a professionally managed association. And the request has to be reasonably specific about the books and records that the person wants to inspect. Next slide, please. Some of the ombudsman determinations round out the statute a little bit. The determinations here, the York and Shears cases, point out what should be apparent, which is that the association cannot and is not required to produce a document that it doesn't have. So that often comes up when unit owners ask for a report or they ask for written responses to questions, things like that. The association doesn't have a book and record that responds to the request. The association doesn't have to create one. The statute just allows for inspecting books and records that are in existence and that are maintained by the association. And it doesn't require that the association generate reports or create new documents in response to an owner's request. Next slide. In the Green Run Homes case, the ombudsman made a distinction for time limits on copying records versus a proper request to inspect and copy. I will say the ombudsman is extremely careful in ruling in direct relationship to the language in the statutes. And this is an example of a fairly tight ruling by the ombudsman that may or may not be the same way that a court would rule on the issue. But in this case, the unit owner had not made a request for inspection and copying as provided in the statute, but instead had requested a copy of certain documents. The ombudsman concluded that there's not a time limit on a request like that because it wasn't an inspection request under the statute. I think as a practice pointer, it's probably a good idea to comply with requests in the 5 business days whenever possible, even if it's just a request for copies and not to inspect and copy, because I'm not sure that if this were challenged in court, I'm not sure a judge would make as tight a reading as was done here. But it is one thing to keep in mind that the owners do have an obligation to be particular and to follow the statute when they're making their requests. Next slide, please. As you heard earlier in Claudia's presentation, I believe, about executive sessions, similar rules apply to being able to withhold certain documents from inspection. The general rule is that the association's books and records are available for inspection, but there are certain things that the association can withhold for various policy reasons that the legislature has applied. One of them is contracts that are still under negotiation. Please note on this that once the association has actually entered into a contract and it's ratified and in progress, the owners do have a right to see those contracts. The ones that can be withheld are bids or proposals or contracts that still are under negotiation and have not yet been completed and engaged in by the parties. Litigation records can be withheld. Attorney-client communications can be withheld. Anything that's in the board packet that is properly designated for executive session can be withheld. Individual unit owner and lot owner files can be withheld. And for condominiums, drafts that are not in the books and records yet can be withheld. So draft meeting minutes for condos don't have to be turned over. There is a requirement that there be redactions. So if a document is partially something that can be withheld, but there are parts of it that are not exempt, then the documents have to be redacted so that only those exempt portions are withheld. Next slide, please. The Ombudsman has inspected the statute and concluded that the association has discretion about what documents are kept in a member's file. And there's really nothing in the statute stating what has to be contained in a member's file or what can be contained in a member's file. And the Ombudsman ruling is consistent on that. So I would say in this, as long as the association is consistent with how it keeps members' files. In other words, if you put a type of document in a member's file for one member, then that type of document should be regularly maintained in members' files for all members. It shouldn't be pick and choose. So if that's done consistently, then there's an indication that the association does have the discretion as to how to maintain those files. I see a question, is an association required to provide personnel file information? There is some requirement for some aggregate salary information for association personnel. Most associations don't directly employ people, so that would be one way to save if it's not actually an association employee. Otherwise, I believe the statute would probably only require that salary information be provided and not anything beyond that. The Park Reston decision indicates that email addresses can be exempt from examination if it's part of the unit owner's file. In addition to that, I think an argument can be made that the statute doesn't require turning over email addresses. It does require turning over a membership list, but that typically is looked at in terms of names and addresses. And I don't think there's a statutory requirement to turn over an email list for all of the unit owners in general, although that's a side note. Next slide. Communication among owners. The statutes do require that the association boards must establish a reasonable, effective, and free method appropriate to the size and nature of the association for members to communicate among themselves and with their board. So that's fortunately not something that a lot of unit owners press, although we are seeing that more and more. But there does have to be a mechanism for the owners to communicate among themselves and also with the board. The statutes also have the requirement that the condominium boards may not require prior approval of the content of anything that's to be posted. So this is really a forum for the unit owners to be able to post their communications. If they want to say that the managers are terrible, if they want to say the board is terrible, then they are allowed to do that in some reasonable discretion that we'll get to here. What's next slide, please? The Property Owners Act does not prohibit associations from adopting guidelines, so there does have to be the free platform. It has to be available, but there can be reasonable guidelines for the use and posting, how long things are going to stay posted, things like that. Those types of practical logistical guidelines an association can get into. The ombudsman has indicated that Facebook and bulletin boards do appear sufficient. Bulletin boards used to be the old school way of satisfying this requirement. People could post their comments on the bulletin board and for all of the unit owners to see. And that was the typical way that this was done. Their electronic ways are much more common now, but I think that still using the old school bulletin board is still available and allowable. Next slide, please. Simply applying the membership list, phone numbers, emails, and a membership directory, that is not sufficient. That's not a means and method of communication among the unit owners or the lot owners. That's just giving people contact information. So there does need to be some platform where there can be an interchange and some sort of an exchange of communications. And again, the ombudsman has confirmed in the statute that associations may not pre-approve messages that are posted. The statute is pretty clear about that. And the ombudsman position is that even if there's defamatory content in what's being posted, the association may not pre-approve or disallow that. Next slide. The ombudsman did rule that an association may remove postings that they believe to be defamatory. Again, this is a very strict ruling reading by the ombudsman based on the definite language in the statute. The statute does not allow pre-approval, but the ombudsman found that once something is posted, if the association finds it to be defamatory, then the association can take it down. Again, I think there may be a little bit, I don't want to say semantics, but I think that the ombudsman is very careful to follow the letter of the statutes. And I think there's nothing in the statute that says you can't take something down if it's defamatory or unlawful statements. So the ruling is you can't pre-approve it, but you can take it down. Obviously, that should only be done sparingly. The association should not be acting as an editorial board. Things should only be taken down if they truly cross the line. And the ombudsman also has ruled that boards are not required to respond to the communications. And that's, I think that's fairly well supported. It's a platform for the owners to be able to reach out, make their comments known, but there's nothing that says that the board has to respond to every communication that's posted, similar to open forum at the end of a board meeting. Next slide, please. This is the rights of potential owners. There's all kinds of details about resale packets in the statutes. The associations are required to prepare disclosure packets, and those packets give purchasers the ability to cancel their contracts within 3 days of receiving them if they see something in there that they don't like. And it's critical to remember that associations are bound by what's contained in the resale packet. So if there are violations on the lot that are not included in the resale packet, the association is not going to be able to enforce those against the new owner because they were not disclosed. So resale packets are critical to get them correct so that the association doesn't lose its enforcement authority. That's the end of my portion. I see a question from Corey. Owner-to-owner communications, plumbing issues. Can the association freely share, connect owners' contact information, such as placing both owners in an email, or do we need to first obtain an authorization and permission? I think it's always best to obtain permission for that type of thing. The statute does require membership lists to be available if a unit owner or lot owner requests it. But I would refrain from disclosing anyone's phone number, email address, or any other information without their permission and without their request. That is the end of my portion, so I believe I'm passing it off to Ed now.
Thanks, Mike. I'm Ed O'Connell, and fortunately for you, I'm the last speaker you're going to get before I move on to the Q&A section. Could you move to the next slide, please? Today I'm going to talk about the Common Interest Community Board regulations. As many of you know, the Common Interest Community Board is a policy board established by statute and is considered a policy board because it has the ability under the statute to promulgate regulations as defined in the statute. Well, to date, the CICB has promulgated 4 sets of regulations dealing with licensing, CIC Association registration regulations, the complaint process, which is the ombudsman regulations, and project registrations, which is condominium regulations, timeshare regulations. Next slide, please. Today, we're going to focus on the manager regulations and the registration regulations. Next slide, please. What's interesting about this is part of the training that you're required to have is to know the changes that have taken place, and effective on December 1st of 2021, the qualifications for licensure as a common interest community manager and for certification as a principal or supervisory employer were revised to exclude marijuana-related misdemeanor convictions from convictions that must be disclosed on the application. So for those of you who had slight indiscretions in your younger years or recently, you no longer have to report that or disclose it. Standards of conduct and practice were revised to exclude this specifically once the statute took effect that permits the recreational use of marijuana in Virginia. Next slide, please. I think it'd be helpful to look briefly at the manager licensing and employee certification statutes. So we're going to go over briefly some of the definitions as they apply as we're going forward. And the first is, what is a common interest community? As defined under the statute, it means a real estate project subject to a declaration. For your purposes, it's any property owners association for management regulations or condominium associations. It does not include timeshare regulations with respect to the manager regulations. A common interest community manager is the company itself. It's a person or business that provides management services to a common interest community. What are management services? Now, this is very broadly defined. It's acting within the authority of the association in business, legal, financial, or other transactions with the association and non-members, executing resolutions, collecting assessments, preparing budgets, financial statements, negotiating contracts, offering or soliciting to perform any of the aforesaid acts or service on behalf of the association. As you see, it's very broadly defined. And with the law focuses on, with the regular folks, with the law focus on, and so the regulations, are certified principal or supervisory employees, which in its simplest state is, bear with me, an individual who has principal responsibility for management services provided to common interest communities or who has supervisory responsibilities for employees who participate directly in the provision of management services to a community association. Direct supervision means, in its simplest sense, oversight and direction of and control of the work of another. So if you're supervising someone in your company, a management company, you're likely considered a certified principal or supervisory employee. Responsible person is simply as what it says. It's the person responsible for providing those services. Regulate means anyone who goes before the board to seek certification or to seek licensure there. So we've talked basically about the definitions. Let's continue to move forward, please. Next slide. Licensing. As I mentioned, license any person or firm offering management services. So it can be an individual or it can be a company. The application disclosures are important. You've got to provide relevant information about responsible persons and principals, which includes, unfortunately, information, a criminal background, such as outstanding judgments or bond defaults, bankruptcies, past due tax assessments, or any relevant financial information relating to providing a management service for the last 7 years. Felony convictions, misdemeanor convictions, except we no longer have to disclose the use of marijuana as described in the statute. And then finally, prior disciplinary actions. Next slide, please. Manager license methods. There's a variety of methods a company can go through or a person go through to get that. One is the AAMC process through Community Association Institute. Also, part of this can provide information about supervisory employees, officers, managers, and principals. You've got to have, of course, the fidelity bond insurance or employee dishonesty insurance, describe who the principal and supervisory employees are, and then compliances with the standard of good conduct practice. Applicant, responsible persons, and principals of the firm all must be people in good standing along those lines. Next slide, please. Certification. This applies to the employees that we just discussed previously, the certified principal and supervisory employees. Again, you have to make the same disclosures that the company has to make along those lines. And then you got to continue with education. Some things that will help is whether you have PCAM status, AMS status, or CMCA status along those lines. Also, completion of an introductory course if you have not had any of those certifications from CAI. Next slide, please. Standards of conduct and good practice, and keep this in mind as we're going forward. It's grounds for disciplinary action. It's important that you do not fall afoul in order to maintain license or certification. It talks about maintenance and management of all accounts of both the company as well as your clients. Please note that the change of business entity requires a new license. We ran into this recently with a client, not a client, I should say, a management company that was managing a number of our clients changed its business type from a corporation to an LLC. As a result, it lost its license because it didn't go through the process. They were eventually able to correct it, but it just caught them off guard. You got to be careful about notices of adverse actions against you, prohibited acts as described in the law. You've got to follow GAAP standards for accounting purposes, and you got to respond to inquiries and provision of records from the CICB and the Ombudsman. Next slide, please. That covers the management regulations and the certification regulations. Any questions? You seeing none? Okay. CIC Association registration regulations. Next slide, please. Here's the recent statutory changes that took effect on regulatory changes that took effect on September 1. The name of the regulations changed to Common Interest Community Association registration regulations. Basically, they enacted clearer procedures for the renewal of a registration, including a 1-year time frame for an association to renew. An association does not renew during the time frame unless reapplied by submitting a new registration application, but you've got more time to do so. Addition of several definitions, including registration and a report. New section that comprehensively outlines association regulations, including potential consequences outlined in the statute that fails. The idea is this: they simplified the process to make it easier to do so, and they've given more time to catch up for those associations that have not registered. Next slide, please. Time frame for registration. As you can see, it's posted up there within 30 days after the termination of declaring control. She'll fully register with a condominium, she'll fully register with the board, so she'll a POA, and so she'll a timeshare do so. As I mentioned earlier, the timeshares are subject to these regulations. The only thing they're not subject to are the manager regulations. That concludes my presentation. I wanted to keep the regulations short and to the point because you've been sitting for now an hour and 45 minutes listening to the program. We're going to turn it back over to Chad, who will take on questions, serve as moderator for questions. Thank you.
Ed, thank you very much. I will read what I see to be 4 questions in the chat, and by all means encourage more questions. Keep us talking till noon. We do have to hit the 2-hour mark to ensure everyone gets credit. And so I encourage questions as you wish. And I love this question from Sanjay, and I especially like who I'm going to ask, my excellent colleague, Marla. Marla, where do most community association management cases end up, in the Supreme Court or Circuit Court? Those are your playgrounds. You tell us.
Most of them end up first in the circuit court. But there's been a shift in the jurisdiction of the Court of Appeals, so that if a case is appealed from the circuit court, it is now going to go to the Court of Appeals first as a matter of right. Meaning we're going to have to deal with some automatic appeals, which didn't used to be the case when previously you had to actually petition the Supreme Court to allow you to appeal. That is no longer the case. So they get a free shot at an appeal to the Court of Appeals. So we're going to start seeing a lot more authority from the Court of Appeals. And then from there is still the option to petition up to the Supreme Court for a subsequent appeal. So I think it's going to make some changes in how we're seeing things done, but we're already starting to see some opinions out of the Court of Appeals, and that's going to be interesting.
So if you find yourself en route to the Court of Appeals, you know who to call. All right, Corey, I am going to direct your question to our excellent colleague, Claudia. And Corey asks, does the EV install requirement / statute specifically to condos apply to non-reserved parking lot spots as well, where the community shares all parking spots? Claudia, what do you think?
So I would say yes, it does apply. The owner has the right to seek permission to install the charging station. And so then at that point, it becomes a conversation that will have to be had as to how the association is going to handle this. But because the statute is specific about the fact that unless your documents prohibit this altogether, the association can't prohibit an owner from installing a station. And so I think the answer is yes, there has to be a conversation of, okay, where can we allow this owner to potentially install this charging station?
Thank you, Claudia. Corey, if you can just let us know if we answered your question, just feel free to reach us in the chat. Claudia, I'm going to keep you in a hot seat. And this is from Sanjay. Does the board have the authority to establish an electric charging station without membership approval? Claudia, what do you think?
So if I'm understanding the question correctly, it sounds like this would be an action that the board would be taking. It's not necessarily a member has requested the ability to install one of these charging stations. And so in that situation, if it's the board that wants to install one of these for the benefit of all or any members, I think the answer is it depends on the documents and what the documents say and what they allow the board to do with or without membership approval at that point, because then we're looking at a capital component. And so the analysis is a little bit different.
Hey, Chad.
Yes, sir.
I just want to follow up on Corey's question a little bit. Corey, was your question as to whether any non-reserved or limited common element parking space in a condominium? Well, here's non-reserved. Okay, non-reserved, the association still has some flexibility. Claudia is right, you should have a conversation with them. But the statute right now talks about they have a statutory right, an owner, to install it within the boundaries of their unit or in a limited common element space. So it doesn't necessarily expand onto non-reserved spaces at this time. I think it's going to in the future as it becomes more prevalent. But right now, the board has the authority to say no for a non-reserved space. It does not for a limited common element or a space should be within the boundaries of a unit, such as a garage parking space that's classified as a parking unit.
And another thing, this, Chad, if I could, on these electronic vehicles, I think that if any association that's going to move into these, the statute provides a certain amount of protections to the association and association property. And so we would certainly recommend adopting an electronic vehicle resolution, where appropriate, a license agreement with the space holder so that you can take advantage of the statutory requirements regarding insurance and protection of the common areas and things like that. It's best to do those things formally rather than informally.
And I can add, it's surprising how much these electric vehicle charging station resolutions can be customized. We're working very hard with one condominium unit owner who happens to be the first unit owner to request an EV charging station. I think we're on our 5th rounds of edits, trying to come up with something that makes sense not only for the unit owner, but to protect the best interests of the association, which has a very old building. We've had to bring in an expert electrician to tell us really what the building can handle. So this is definitely an area that's evolving as we speak. Okay, I'm going to put Claudia back in the hot seat. And Miriam asks, Claudia, may the board prohibit smoking marijuana in a unit owner's unit?
Yes, so the statute just references smoking. And so marijuana, if somebody's smoking marijuana, then that would fall under that restriction. And so what we do typically in our smoking resolutions is we address that. What does smoking mean? Well, smoking isn't just what you might think of right off the bat, like a cigarette, perhaps a cigar. It'll be a vape, marijuana, any form of smoking.
Chad?
Yes, sir.
Just to elaborate on what Claudia is saying, with the thing you need to be cognizant of is look at your rulemaking authority in your governing documents. What the statute gives you that is, what we know from what the courts have told us is this: the rule has got to be reasonable. So think about what you're trying to address. If you're just banning marijuana because you think it's bad to, it's not the thing to do, or you're against marijuana, the answer is no. If you're trying to address an association such as the odor associated with it, you may want to think about applying the regulation across the board to all lit products, tobacco, vaping, and marijuana, rather than just limiting marijuana. Look at the purpose you're trying to address. And talk to your association attorneys. Okay.
Thank you, sir. I'm going to keep you on the hot seat. We've got a question from Tammy. What if you have no resolution, meaning my building is not a non-smoking building? We're getting a lot of complaints about marijuana smoking and health risks. Ed, what do you think?
Well, the statute gives you the authority to do so. I'm just pulling the statute up as we're speaking to take a look at it again, but you've got the authority to address the limitation of smoking in condominiums. What the statute said, as Claudia mentioned, is the board may establish reasonable rules that restrict smoking except the extent the condominium interests provide otherwise. So unless your documents say you can clearly smoke, which the most likely they don't, the board may establish reasonable rules that restrict smoking in a condominium, including rules that prohibit the smoking in the common elements and within the units. And they may be adopted in accordance with section 55.159, which is your enforcement provisions that we talked about earlier, suspension of privileges and imposing monetary charges. So it doesn't have to be in your documents. The only thing you need to check to see if your documents prohibit you from banning smoking in the building.
And I think that if I'm reading the question right, if there isn't a resolution and you're getting questions and complaints from other owners about marijuana smoking or anything, then it's treated as any other violation. So you go through and generally that means there's going to be some sort of a nuisance standard that's going to be implied or impacting other owners. So I think that if the building chooses not to adopt a resolution, and I can understand why they wouldn't, there's a lot of controversy to either ban or not ban, then it unfortunately gets treated as a regular violation. You've got to go through the violation process, determine if it's bad enough that it becomes unreasonable and that you can actually pursue it as a violation under the bylaws.
Thank you both. I'm going to segue to a question from Rosemary and Katie. What do you think about for hearings? Does the association have the authority to require that an owner provide notice of their intent to bring an attorney? Can the association do that?
I would say no. The statute's very clear that the owner has an opportunity to be heard and to be represented by counsel. What I would suggest is in the notice of hearing, advising of that right and requesting that the association be on notice in the event the owner is going to bring an attorney with them. And that way the association can then be prepared to have their attorney present. In the event that an owner fails to notify the association that they are planning to bring an attorney, I would suggest at that hearing, the manager or board attempt to contact their attorney so that at least they can be on the phone listening to the hearing. That would be my advice.
And I agree, Rosemary. I think that an owner can show up with an unannounced attorney. You're speaking to a bunch of litigators, and I'll let you in on one of our little secrets. One of the most nervous times we have is about 5 minutes before court to see if a pro se litigant will in fact bring an attorney. So I think it's very similar by design to these opportunities to be heard. It's just not something we can compel an owner to disclose. It's completely up to him or her whether she wants to bring an attorney announced or unannounced. But I'll make a segue because I've got 5 minutes to fill. Think of opportunities to be heard, not necessarily as controversial. It is a perfectly appropriate purpose of the opportunity to be heard to try to work with an owner who shows up who may need more time or may not understand what's being asked or may just not have the funds. It's okay to use those opportunities to be heard to try to seek resolution. And in many ways, when an attorney appears, the attorney's on board with that. As opposed to trying to contest the allegation that the lot or unit is in violation. Let's see, I see some new, so thank you very much, Katie. I'm going to ask a question from my good friend Diana. Nuisance. I'm going to give this one to Nassim. We're going to give you a nuisance question. Nassim, can children running in a condo hallway be part of a nuisance complaint? Children disturbing owners at all hours, 2 a.m. on weekends, etc. How do you feel about children running in the halls at night?
Well, again, it depends on what the documents specifically say with regards to what authority the association has. Keeping in mind the fair housing laws with regards to whether or not you want to allow children in certain areas of the common area. So you have to be careful in terms of what authorities and what restrictions you put on nuisances that are caused by children. And definitely whatever the general rule is, what disturbs the peace and enjoyment of the unit owners or lot owners. So it all depends on what authorities the association has per the documents.
And I think maybe Mike will supplement me on this because I know we've discussed it. Neither of us believe the prohibition on nuisances is as broad as we would like as homeowners ourselves. At least at the moment, the Virginia Supreme Court that has spoken on nuisances talked about a case where a lot owner had horses. And does that case apply to things now such as children running in the hallway? It's an open question, and we think you're going to have an evidentiary issue before you go to the court. But Mike, would you like to share your opinions on nuisance cases as well?
Yeah, and these nuisance cases are very difficult. Nuisance is a pretty high bar to establish. I certainly think that if it's about children running in a condo hallway, I'm surprised that Marla isn't spinning around
I've been over here biting my tongue.
Yeah, it's a danger area. To try to say that children constitute a nuisance, I think it is definitely not the way you're going to want to go. You're going to be inviting a Fair Housing Act complaint, and you're probably going to lose, no matter how loud and obnoxious the children are. I think trying to tell people that they have to keep their children quiet is not a good way to go. So unfortunately, that's one of those things that the federal statute is very difficult in terms of being very strict, and sometimes the nuances get caught up in it. It's certainly, I think people can consider it to be a nuisance if it's in the middle of the night and it's disturbing people's sleep and things like that. But the fact that it's children, I think, is a danger zone. And I don't know if Marla, you want to weigh in any more on that.
Yeah, I mean, that would be my major well, I have two concerns with it. One is, does it really reach the bar of nuisance? As both Chad and Mike have mentioned, that really is a pretty high bar to try to clear in terms of whether the conduct is really, I mean, the origin of nuisance law in Virginia has to do with the odors and smells from funeral homes that were driving out neighbors. So if that's what your bar is, children running in the hallway isn't getting anywhere near that in terms of making your home unlivable. So I'd be very cautious about that. But if what you're talking about is trying to regulate children, then yes, please do not under any circumstance use that. You want it, I mean, it could be 22-year-old college students that are running down the hallway at 2 a.m. making too much noise as well. Just treat it as a person making too much noise and disturbing other owners' peace, and try to deal with it that way, and disregard that it is the age of the individuals involved, and will avoid any sort of fair housing issues.
Thank you. I just want to point out that we have reached the 2-hour mark. We are more than happy to continue to speak with whoever wishes. If anyone was here for the credit and wanted to receive it, if you've hit 2 total hours, you are all by all means can leave us if you wish, and we will make sure you have a certificate. I do see a couple of questions left. We'll hang on the line to answer those. And Sanjay, I think I can speak to your point. You are correct. This fulfills 2 hours of the 4 hours that I think the CICB requires from supervisory employees, and it's specific to the common interest community law. Oh boy, and regulation updates. There's another 2-hour course that is required on fair housing. We have not yet put together our materials on that. But we do have it as a goal for the end of this year. That said, if you want to reach me offline, I'll be happy to recommend many good friends who do have that approval. I understand how tough it is to find these courses, or at least I have found out in the last couple of weeks. And Tammy, I'm going to come back to your last question. So what if, Mike or Marla, if your documents say the hall shall be used for normal paths of travel only, can we prohibit not only children, but Mike from running in the hallways?
You can always prohibit me from entering any building in the Commonwealth. There are several orders to that effect in various courts. I think that Marla's point is the key point. I think you treat it as any other noise or obnoxious thing going on in the hallways. I think you, I think that the letter would go to the unit owners, as we typically do. I think that you don't frame it as children making noise in the hallways. I think you frame it as unreasonable disturbances in the hallways in the middle of the night. I think the difficulty with saying the hallways are for normal passage, you're going to get yourself slipping into an argument saying that children shouldn't be allowed to play in the hallways. And I don't think that you want to go into that. That's going to get you into trouble. So I think Marla's approach of focusing on the noise and the disruption, and again, making sure that it actually rises to the level of a disruption, is going to be the way to go on that.
Yeah, I agree with all of that. And, you know, the other thing too is I don't ever want to be in court representing you trying to argue that it's unreasonable on occasion for people to run as reasonable passage. That is such a tricky argument. I just see the judge looking at me now saying, so Ms. Diaz, you don't ever think it's reasonable passage to run, that human beings can only walk? At what speed is it unreasonable? I don't ever want to be making that argument. Try to focus on the disturbance, try to focus on whether it actually is negatively impacting other people. And let's try not to regulate speed of passage, because I don't want to make that argument.
Well, thank you. I think that brings us to the end of the questions in the chat. I am pausing very slowly to see if anyone else wishes to ask us anything on their mind. Otherwise, we thank you so much. I believe as long as you hit the 1 hour 50-minute mark, that gets rounded up to 2 hours. So you certainly get your credit. If you're not yet at the 1 hour 50-minute mark, please keep us talking until we get you there. Otherwise, I'm going to turn this back to Rachel, and we are just so appreciative that you joined us on your Friday morning. And by all means, if you have questions afterward, reach out to any one of us. I can tell you as partners, on behalf of Mike, Marla, and Ed, nothing makes us beam more than seeing how excellent Nassim, Claudia, and Katie acquitted themselves today. We taught them everything we knew. So anyway, if you ever see us, pull us aside and say hello. Rachel?
Thank you, Chad, and thank you, everyone. Congratulations, you made it. And we thank you again for joining us for the Virginia Common Interest Community Law and Regulation Updates. Just as a reminder, you will be receiving an email with a link to this recorded presentation as well as the slide deck. And as Chad mentioned, just to remind you, if you have met the attendance requirement for the timing here, you will be receiving a course completion certificate, which will also be emailed to you. So on behalf of all the presenters and Whiteford, Taylor, and Preston, thank you so much for joining us this afternoon, and have a wonderful weekend.